In the last video, we talked about the timeline after you file for Chapter 7 bankruptcy. Now you're going to be preparing for your Chapter 7 meeting of creditors. So this meeting will be conducted by your Chapter 7 trustee. This trustee is randomly appointed by the United States Trustee's Office, and it'll be one of 8 current trustees that we have in the Southern District of Texas. We call it the 341 meeting because that's where this information is located in the Bankruptcy Code. All right, so when we're preparing for your Chapter 7 meeting of creditors, when we're in the conference room, there's going to be a list outside that room that includes your case and all the other cases that are scheduled for that day. Typically, the Chapter 7 trustee will conduct around 3 to 4 meetings every half an hour. Now, these meetings can run long, so they don't always start on time. It just happens. Just keep that in mind. So when ready, the trustee is going to call your case. Now remember, these meetings are held in a conference room with the trustee. They're not held in a courtroom, so I don't want you to freak out. Now the trustee must verify your identity and your Social Security number. So make sure you provide your government-issued ID, like your driver's license. And you want to make sure that you provide proof of your Social Security number. This can be your Social Security card, or it can be something like a W-2 or a 1099, some official government document that has your Social Security number on there. Now, when we go in, the trustee is going to have you and me sign in to verify your attendance. And then just understand the meetings are being electronically recorded, so we want you to speak up. The trustee is then going to swear you in. They're going to swear you in to tell the truth and nothing but the truth. A lot of times we call this taking the oath. The trustee will then ask you standard questions about your case. For example, did you provide your lawyer with the documents needed to prepare your paperwork? Did you review that paperwork with your lawyer before you filed your case? Did you personally sign those documents that your attorney prepared? And then, did you list everything you own? Because this is important. You are required to list all of your assets, so make sure that you've got them all listed. Trustee will also ask if you have any claims against anyone, or more or less, can you sue anyone for any type of money? Trustee will make sure that you understand you have a duty to let them know if any of the information in your paperwork changes. And the trustee will ask, do you understand that you can file the other types of bankruptcies, the repayment plans like Chapter 11, Chapter 12, and Chapter 13? And then finally, the trustee is going to want to make sure you understand the effect and the impact of a discharge on your credit report, because it will impact that. And then some trustees do like to ask about what happened, basically what caused you to have to file bankruptcy. Now, you don't have to have an elaborate answer, and a lot of times I call it your elevator speech. So just spend a half a minute to 1 minute explaining what happened, what led you here to this place where you needed to file. All right, and then that's it. Congratulations. It seems a little anticlimactic, and I agree with you, but it's not designed to be a long or arduous type of hearing. The trustee's job is just to go through your information, and generally the trustee will recommend that this be a no-asset case. And folks, that's a good thing. That means the trustee won't be taking any of your stuff. So when that meeting is completed, we're going to focus on what comes next after you get your discharge. Watch the next video. Thank you.